Proctor himself acknowledged this fact in 2017 after 4 years on the job, telling his friends, quote, "No idea how I passed the background." Same. Karen Reed has dropped a new lawsuit. There's a court hearing from yesterday that I had been wanting to get to. We have some other docket updates. We have a busy docket tomorrow. We have a lot. We are going to cover the new Karen Reed lawsuit. We are going to cover the hearing from yesterday. It's not that long. Gird your loins.
So at one of our recent status conferences, there had been one deposition that had been conducted. I think the last time we got together, there had been 2 depositions conducted. So I'm hoping there have been at least 4 conducted, but I guess I'll have to find that out. So why don't we start with Attorney Diller on behalf of the plaintiffs?
Yes,
what depositions have been taken?
We've taken all 3 of the depositions that have occurred to date, Your Honor.
So we're up to 3?
There have been no additional depositions since we last got together?
We took 2 depositions since we last got together. Some of the depositions that were also noticed had been canceled.
Oh dear.
Okay. What depositions do you have noticed that haven't taken place?
We have 12 additional depositions noticed that haven't taken place. One of which we had a meet and confer with the Reed team regarding the deposition of Paul Mikowski. We're trying to figure out whether or not we need to move forward with that deposition or whether that's going to become an issue that's live for trial. We also were asked to take the deposition of Karen Reed off for the June 19th, and we're trying to put that on for June 24th, Your Honor.
Attorney Rosenberg, why does that deposition have to be taken off?
Well, because June 19th is a federal holiday, Your Honor, and multiple offices are closed.
Because they scheduled it on a federal holiday, that's why.
So we're not, first of all, it was noticed first in, I believe, mid to late July. And then Mr. Diller re-noticed it for June, which is fine if the date's available. But he picked a date where offices are closed and it's a federal holiday and we are not available. We are fine with rescheduling.
I wonder, how many, I wonder how many of the attorneys on the Zoom call have their offices open on that day?
Your Honor, they scheduled it for July and then they tried to bump it forward without asking the other side. So, no.
I don't know the answer to that, Your Honor, but I know it's a federal holiday, and if one party determines that they're going to hold a deposition on a federal holiday and the others aren't available, that seems relatively reasonable to me. As I was saying, though, we provided additional dates.
Hang on, Attorney Rosenberg. Just keep in mind in all the discussions we're having today, the context of this case and where we stand and how long discovery has been ongoing.
I don't know why you're mad at Rosenberg. They set it for July. They bumped it forward on to Juneteenth, which is a federal holiday. Offices are closed. The end.
And how few depositions have taken place. That's the background that I'm coming from. So it wouldn't surprise me if an attorney would decide to take a day that would be open for most people to conduct a deposition. But your office is closed, so that's fine.
Well,
I mean, our office is closed too.
But also, respectfully, Your Honor, the case has been going on for different parties for different lengths of time.
That's a fair point.
My clients only had active discovery pending for a year. Mr. Diller chose one date. And
I mean, that's a really good point, Attorney Rosenberg, because look, Attorney Rosenberg has not been in active litigation on this case because it was stayed during the criminal case. Let me remind you. While the criminal case was ongoing, Karen Reed's part of this case was stayed. But as to the bars and as to the plaintiffs, it was not. So Diller could have done all the depositions or could have asked to do the depositions with regard to other parties before the criminal case was done for the Reed parties, because it was not stayed as to everybody. They didn't.
And then rescheduled to another date. And the second date he chose happened to be a federal holiday. We proposed 4 other dates earlier than what Mr. Diller
That's
had
some new
first
information.
chosen, and we are willing to reschedule it. The only reason that that date doesn't work is because of the particular date that he chose. So we are happy.
So what dates do you have before?
Your Honor, we're not making our team come in on a federal holiday. We are recognizing the federal holiday. I think in Massachusetts, it's also a state holiday. People are off. We are giving them the day off, and we are not making them work on this deposition that day.
June 19th.
Before June 19th, I believe we don't have any, because the vast majority of them are taken up with scheduled depositions.
And this isn't directed just to you, Attorney Rosenberg, but it's just beyond belief to me, the number of...
Did you hear the judge? The judge is big mad about the delays in discovery and did make a point to say, it's not just you, Attorney Rosenberg. The judge is frustrated with everybody.
The number of experienced lawyers involved in this case, the length the case has been pending, for however long it's been pending.
The court's like, get your shit together, everybody.
And even if it's only been pending for Ms. Reed for a year, that there are so few depositions that have taken place. I want to know what's going to happen.
Well, that's what I'm trying to explain to you, Your Honor. If you'd let me just say that. So, for example, we had depositions of the following 6 individuals noticed.
Attorney Rosenberg, I don't care what has happened now, all right?
No, I'm talking about in the future.
It's obvious that the parties are having difficulty working together.
He's just trying to
So what I want to hear
explain-
from all of you is what you're going to do to get this done.
That's
so
what I'm
tell
addressing.
me what you're going to do to get this done from your perspective.
The judge is
That's
so
what
mad.
I'm trying to address, Your Honor. If you would please let me explain. We have 6 depositions that are currently scheduled in the future for the following 6 individuals who are major witnesses in this case from my client's perspective. Brian and Nicole Albert, Jennifer McCabe, Matthew McCabe, Allie McCabe, and Brian Higgins. They've been noticed and subpoenaed for a month. Last night at 9:35 p.m., we received an email from the single attorney or firm that is representing those 6 individuals.
What?
Telling us none of them are available for the dates on their subpoenas. And with one minor exception, none of them are available prior to July 20th. So respectfully.
What? This is why civil law is exhausting. The level of gamesmanship fuckery is so difficult. So I am not surprised that they got an email and we're just like, we're not available.
That it's not nitpicking, I believe, to say that the reason that we've had trouble taking depositions in this case is because this is not the first time that
they are fucking around.
The witnesses have, in our view, played games with the scheduling. And so I'm not interested in coming to you every time this happens, Your Honor, but if you want to know why we are struggling to take depositions, it's because third parties are not showing up for subpoena deposition dates.
Hey, Your Honor, just a suggestion. Start fining people. Start fining people. If they want to fuck around with the depots, just cha-ching, just make them pay for it. There's got to be a cost.
And there's already one motion to compel that has already been served as to the first of those witnesses you will receive probably in a week or so. And once we confer on this email that came in at 9:35 tonight or last night, unfortunately, it appears you're likely to see a number of other motions to compel on this. And we will, per your instructions in the past, we will do that quickly, and we'll get them to you as soon as we
Sanctions.
So I guess you're all going to have to engage in motion practice if you can't get people to show up for depositions.
can. Agreed.
Well, we don't follow a ton of civil cases here through all of the discovery process. There's a lot that happens. We don't always have streamed hearings of civil cases. It tends to be criminal. But we are starting to see more interest in civil cases. And because this case started criminal and is now into the civil realm, I think we're going to see, well, more easily available coverage like this. So where are we at in the wrongful death case? The judge is so done with the languishing discovery and the languishing depositions, because nothing can move forward until the depositions are done. And the judge has already looked into the future and said, when you're all back here asking me to extend the discovery cutoff, I am going to ask about who did what, where, when, what depots got moved forward, what depots got canceled, and how everything is happening. I'm going to ask then, but for today, what can I do to move this along? And it seems like the next step is going to be additional motions to compel, meaning the lawyers are going to go into court and say, Your Honor, we followed all of the process to get deposition documents, digital evidence, whatever it is. We followed the proper procedures to get the shit that we're asking for. And they are refusing to give us the shit. And we have tried to resolve it ourselves, and we have followed all the rules, and we have met and conferred, and they will not give us the stuff that we are asking for. And we are coming to the court to say, make them give it to us. And then they're going to argue, no, Your Honor, you can't make us give them whatever the thing is because reasons. So we are now seeing that both the plaintiffs, which is the estate, and the O'Keeffes et al., that the plaintiffs have motion to compel that they are contemplating regarding things in the possession of Turtle Boy. And we have heard that Reed's attorneys have motions to compel regarding document discovery in the possession of Colin Albert. And now that the McCabe's, the Alberts, and Higgins all said, we're unavailable for our depositions. And so there will be motions to compel for that as well. So the motions to compel are essentially, Mom, they're not doing what you told them to do. Yeah, make them do it. It is going to the court to say, make them do it. And we have seen that happen in this case numerous times. There have been a lot of motions to compel on calendar. And the court said at an earlier hearing, if you're not getting stuff, you have to stop waiting so long before you bring it to the court. If they are not adhering to your subpoena, do not wait 3.5 months to be like, maybe they'll do it. Meet your statutory obligations to meet and confer, and then bring it to the court immediately. Stop delaying. And so I think we are going to see the motions to compel speeding up. But also based on what I've seen on the docket, it seems like at least with regard to the city of Canton, the motions to compel have been resolved. So now we need to look at the city of Canton getting sued. Leonard, a quick thank you to our sponsor, Jones Road. You know I love a simplified routine, and I've talked about simplifying my makeup routine literally as much as possible. And Jones Road plays a huge role in that because their makeup has been so easy to wear and is great for your skin. I love that they also have the Miracle Balm. I have the one that is just completely sheer. I absolutely adore this product, but Jones Road just added a foundation stick to their lineup, and I cannot wait to try it. I love a foundation stick. It makes it so easy to build where you want it to get a nice, clean canvas for your makeup. The new foundation stick, just like all the other products, is packed with skin-loving ingredients so that you're getting dermatologist-tested makeup that's also nourishing your skin while you wear it. And you can really feel the difference when you're wearing Jones Road, that the makeup doesn't feel heavy on your skin. It is like wearing skincare that also just makes you look fresh. It's modern day makeup that's clean, strategic, and multifunctional for effortless routines. And for a limited time, Lawnards get a free gift with their first purchase when you use code EDB at checkout. Just head to jonesroadbeauty.com and use code EDB at checkout for your free gift on your first purchase. And If they ask how you heard about them, let them know it was the Emily Show. Case briefs. And now, let's get back to the brief. Canton police sergeant allegedly linked to Proctor texts has resigned. Sergeant Sean Goode, who worked the early investigation in Karen Reed's murder case, had been on leave since last fall amid an internal affairs probe into misconduct allegations. This was yesterday. I bet they got a copy of the lawsuit served yesterday before it got filed in court this morning. Canton police sergeant who worked the initial investigation in Karen Reed's murder case has resigned following allegations that he exchanged eyebrow-raising messages. I don't know if that language is going to be strong enough. With the case's lead investigator, former Massachusetts State Police Trooper Michael Proctor. Sergeant Sean Goode submitted his resignation to Canton Police Department effective Tuesday, town officials said in a statement. Goode had been on paid leave. Thank you, chat. Goode had been on paid leave since last fall amid an internal affairs investigation into alleged misconduct. Quote, his resignation does not alter the completion of his investigation, which will be submitted to the town and the Police Officer Standards and Training Commission, town officials said Wednesday. What does that mean, Emily? It means that they are going after his retirement. So they are not allowing his resignation to end their investigation. They are going to finish his investigation and then decide what happens, which means depending on what they do, they could deny him his retirement. But his resignation means that he, in theory, does not have grounds to fight any termination back at civil service, which will actually save the taxpayer some money. So that's a good thing, because if they had just terminated him without following proper process, then he could turn around and sue them for not following civil service process and then end up wrapped up in a lawsuit with the city of Canton. So him resigning helps out the city of Canton if they determine that he will be terminated, and then they can go after whether or not he is entitled to his retirement or not and things like that. Karen Reed versus Massachusetts State Police and the town of Canton. The not guilty verdict in Commonwealth versus Karen Reed on June 18th, 2025 did not merely end a wrongful prosecution. It shone an unflinching spotlight on something the Massachusetts State Police, hereafter MSP, and the Town of Canton Police Department, CPD, I'll probably just also call them Canton, have spent years trying to conceal: an embedded culture of bigotry, misogyny, systematic failures, and institutional rot at the very core of both organizations. As a result of this entrenchment, Ms. Reed now files this action against MSP and CPD. And again, CPD, Town of Canton, Canton is being sued for their negligent hiring, training, and supervision of biased and corrupt police officers whose actions violated her constitutional rights and caused her immense harm. She is suing a number of these officers personally in the federal suit for deprivation of rights, for the constitutional rights. So that is in a separate case. Former MSP Detective Michael Proctor and former, as of 2 days ago, I guess it's in here too, former, as of 2 days ago, CPD Sergeant Sean Goode are virulent bigots whose hatred for anyone and everyone different from themselves preeminates their every action. They are not officers who occasionally voiced an offensive remark. They are men whose written and recorded communications, recorded communications? They are men whose written and recorded communications sent to one another and to a circle of like-minded friends over the course of a decade establish entrenchment and unrepented hatred for women, Black Americans, Asian Americans, Jews, Hispanics, Arabs, and gay people. Their unfitness for any position of public trust was not subtle. And this is where the failure of the departments comes up. It was extensively documented and, as set forth below, knowable to MSP and CPD long before either agency assigned them to investigate and prosecute Ms. Reed. I'm very interested to see what they allege to show that the departments knew this before. Proctor and Goode's hateful and despicable views were not only part of their own daily vernacular, but were woven throughout the fabric of their organization's culture and everyday conversation. I am not reading much of what is on this page. The first text message that's illuminated is Proctor texting Goode, who is a Canton sergeant, regarding a multi-vehicle collision, and texting, quote, and I'm not going to read everything in this because slurs, but texting, quote, actually take your time. I saw that slur, a black individual, was involved, so I wouldn't rush if you're working, let them die. What the absolute fuck? That's the first message they share between Proctor, MSP, and Canton, telling him not to respond to a vehicle collision based on somebody's race. Listen to this descriptor. My new VP, this is from Proctor, my new VP is a giant malignant SP. He put that in there, SP. I pray to the heavens that some fucked up insect from the Amazon crawls up her vagina, hatches eggs, and then the litter kills her by eating her from the inside out. And then we get into, it seems like, someone else's balloon knot, to borrow a word from Proctor's other diatribes, because this is a Proctor text referring to his then girlfriend's rear. Quote, I can't even get fucking near that thing. I make every effort possible. I wait till she's asleep and I try to get at it. Sir, consent is a thing. I try every effort possible. I try to get her hammered. I can't get anywhere near it. Sir, consent is a thing. It continues with him decrying that Canton High School has more black students than it did when he was there in offensive and horrific ways. The plaintiffs found a wide variety of slurs. There is a text that I heard alluded to in other cases where Proctor is talking about it should be punch slur day in Canton today out of retribution. The last selection they include at the bottom here really just puts a bow on what Proctor's thinking and where his head's at. They discussed sharing private nude pictures of women. What? And intentionally ejaculating on women while they slept. Back to the consent conversation. Because after the last conversation, I have a hard time believing that consent is involved in any of this. They go on to say, put simply, there were then and are now completely and unquestionably, or they, completely and unquestionably unfit to hold positions of authority within MSP and CPD, much less play important roles, or in Ms. Reed's case, the primary role. Oh yes, because the case officer in homicide investigations. And they go on saying, despite that, CPD had received, reviewed, verified, and analyzed these same messages nearly a year ago, Sergeant Goode remained employed with full rank as a sworn police officer by the CPD until 2 days ago. They go on to say, among other failures, MSP and CPD's delegation of power and authority to those as biased, corrupt, and bigoted as Proctor and Goode led to Ms. Reed being wrongly accused of homicide for 3.5 years and subjected to suspicion, to arrest, to prosecutions and public trials and public condemnation. Indeed, With the exercise of ordinary care, both MSP and CPD would have known that Proctor, Goode, and others were unfit for service from the beginning. Proctor himself acknowledged this fact in 2017 after 4 years on the job, telling his friends, quote, "No idea how I passed the background. Same." Now, after being twice acquitted of all charges related to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address MSP and CPD's actions, inactions, and negligent failures to ensure that justice was sought and served in the aftermath of January 29th, 2022. Oh, this shit's going to be expensive, Massachusetts. They go on to say, to be clear, this complaint transcends Ms. Reed's personal and actionable grievance. Rather, this lawsuit is a clarion call for reform and accountability. Cloaked with the emblem of authority, MSP and CPD and their employees, Proctor, Goode, and others, betrayed their sworn commitment to uphold the law. Their prejudices undermine our very democratic principles in wielding the great force of government over those who are vulnerable and powerless. MSP and CPD's cultures of intolerance, hidden from the public but in plain sight within the organizations, cannot stand unchallenged. MSP and CPD are culpable and must confront the consequences of their institutional negligence. Even during MSP's hiring process, Michael Proctor could not contain his bigoted views. On February 26, 2013, Proctor wrote to his friends, "Hey, dickheads, just want to give you two a heads up that you guys may get a call from a state trooper named Scott Cooper, the state trooper, who is doing my background check. Don't know who far back they are going to go with this stuff, but don't want to have this guy catch you off guard." Proctor's friend's response, "No problem, but what are we supposed to say? Last time the BPD lady was grilling me for exact dates as to when and how long you lived in Brighton, how we pay rent, to who, etc. Anything specific we should be aware of." Wait, he interviewed for Boston PD? That aside, Proctor responded with slurs. He responded with slurs. That lady was an absolute rag N-word who had it in for Bear, referring to himself in the third person by his nickname Bear in his friend group chat. Ew. Talked to this guy for half an hour today, and I would be shocked if he pulled the same shit as her just from how she acted with me on the phone. Oh, she clocked your shit. Much of Proctor's aggression and hatred, however, was directed at women. In fact, from the time he was hired at MSP through the time he began investigating Miss Reed, Proctor shared countless messages with his friends about his perspectives on women. I do not want to know about Proctor's sexual proclivities. Discussing a sexual partner not wanting to be ejaculated on, quote, "That's when you whack off on her when she's asleep. Then tell her one way or another you will spray a rope on her." No, sir. Discussing specific sexual acts and the need to potentially, quote, "get at it while she's asleep." Well, that was up above. Discussing needing a roofie or something to find a sexual partner, quote, "ain't gonna happen. She will pass out at 9 and I will stay up until midnight drinking and watching movies. I could swoop in for the kill when she is asleep, though." So consent's just not in the vocabulary. It goes on to say, in addition to these horrific statements indicating the extent to which he believed those with backgrounds and characteristics similar to him were superior to others, well, he's made the superiority apparent. Proctor also wasn't shy about his other proclivities. Please do not make me read any more. That made him patently unfit for service, including that more than once Proctor discussed, quote unquote, planting coke on people and shoving a nightstick up someone's ass. The planting evidence is going to be interesting when you get to the wrongful death lawsuits and all of the other lawsuits. Proctor recognized his inadequacy in 2017. I'm sure he recognized it long before that, writing that he had, quote unquote, "no idea how he passed the background," although he did explain that MSP detectives units do the background check for applicants. They allowed a girl into the next academy who admitted to using cocaine and ecstasy. and recently used those drugs. Like Proctor, Goode exhibited more in these messages than just his bias and hate. He also showed that he lacks basic discretion. No shit. He lacks basic discretion and neutrality required of a police officer deputized to protect and serve all members of the community, regardless of skin color, ethnicity, gender, religion, or sexual orientation. It goes on to say, as just one example, in 2022, as an 18-year veteran of CPD, Goode shared his views in writing on Sandra Birchmore, a young woman who tragically died the year before in Canton. She was murdered, and whose death was initially ruled a suicide until federal authorities discovered that multiple officers from the neighboring town of Stoughton Police Department had been sexually abusing Ms. Birchmore when she was a minor. After federal authorities investigated, they charged the former police officer with her murder, and her death is now classified as a homicide at a federal level. The Norfolk County District Attorney's Office earlier this year changed her death from suicide to undetermined. And against this backdrop, Goode told his friends that chick was borderline R-word. She was a police explorer who was abused by multiple police officers that were in charge of the Explorer program. Sergeant Goode, but it seems that empathy is not something that you're aware of. Goode also helped his friends avoid repercussions for what appears to have been their regular practice of driving drunk. This is a quote text message. Sobriety checkpoint on 138 by the trail side tonight. Please stay away tonight. Can't help if you get caught. Too many troopers and Milton PD. Keep this info between us. MSP and CPD knew or should have known about Proctor and Goode's bigotry. Proctor and Goode's biases, bigotry, and personal histories were known or should have been known to MSP and CPD when they were hired, trained, promoted, and supervised. Not only were the MSP and CPD on notice about their troubling views, intolerant attitude towards various members of the community. I mean, practically all of the members of the community. Their troubling views and intolerant attitude towards various members of the community that they were sworn to protect and serve during the underlying investigation of Mr. O'Keefe's death. But Proctor's supervisors knew Proctor had a close relationship with the Alberts, and that Proctor made no secret of his bias against Miss Reed, demonstrating a clear prejudice against her from the outset. CPD refused to acknowledge its role in this debacle of an investigation or recognize the significant flaws in its hiring, training, and supervising practices, illustrated by Goode's continued role as a sergeant for the CPD until 2 days ago, when, upon information and belief, CPD was informed of MSP. Oh, wait, there's T. Come on back. They say that Goode's continued role as a sergeant for the CPD until 2 days ago, when, upon information and belief, CPD was informed by MSP's counsel, that's Mass State Police's counsel, that this complaint would soon be filed. Because Goode was still on leave, paid leave, we've learned. Goode was still on paid leave during the IA investigation. So then they say, helpful right to the end, CPD then permitted Goode to resign 2 days before the filing of this complaint, rather than firing him, and thus saving him from the reputational and financial implications of being terminated for cause. I have questions, and I think the town of Canton is going to have questions, and I think the town of Canton should have questions. Counts. Count 1, negligence. So this is going to be the negligent hiring, the duty of care, the hey, you can't just ignore all of that because your officers can cause harm. So count 1 is negligence against MSP. I imagine count 2 is going to be negligence against Canton. Count 2 is negligence against Canton. Again, hiring practices, supervisory practices, et cetera, et cetera. Count 3, civil conspiracy against both defendants. So this is amongst the departments, not the individuals. The individuals are charged elsewhere. MSP and CPD had common design with each other and with Proctor, Buchanan, Tully, and the occupants of 34 Fairview Road the morning of January 29, 2022, to unlawfully and improperly direct the investigation into the death of John O'Keefe towards Miss Reed. Prayer for relief. Miss Reed is asking for an award of damages, an amount to be calculated at trial, along with pre and post judgment, interest, costs, and expenses, reasonable attorney's fees, such other relief. Respectfully submitted, Karen Reed, by her attorneys, Alan Jackson and Aaron Rosenberg. So when we started hearing about the Proctor texts and the Proctor problems, I was not prepared. Like when Yannetti talked about some of it in opening statement, I was like, holy shit. And then when Proctor was on the stand in trial 1 and was going through some of the text messages, I was like, holy fucking shit. I was surprised. It also gave maybe a little insight about why all the other phones just went missing. When we started getting into the Proctor termination proceedings, I was surprised that the feds kind of sprung upon him the text messages that they had gotten to. I think Proctor was genuinely surprised that they had gotten those messages. And then I think he was genuinely surprised that those messages got into the hands of defense attorneys and then got into the hands of the prosecutors. But I can't imagine the level of surprise when Proctor's defense attorney for his appeal of his termination at civil service that was handled by the Police Officers Association, by his union, when his attorney confidently stated to everyone, I don't know how much you're going to get from his personal phone. Like, he lost a phone, he broke a phone, he's got a new phone, who this. There's not going to be really anything there. Also, the phone auto deletes. So I don't know what you're going to get. And then the prosecution came back and was like, so we got like thousands and thousands and thousands of texts and photos and videos and audio messages and like everything in his iCloud. Like, we got his whole iCloud back to 2013. So so it turns out we have everything. And then that day, Proctor immediately dropped his appeal. His union attorney dropped him for all cases. And then Goode was put on leave. They were still fighting for this never to see the light of day. I have no idea what the animosity between Goode and Proctor might be, because it seems like most of this from Goode is coming from Proctor's phone. I also think we are going to see this used as a push to get more officers' private phones, their personal phones. I don't know how that's going to go, but if there is any inkling people are using their personal phones for work, this is going to be a cautionary tale to courts, where I wonder if courts are going to start looking at disclose more, because we are seeing defense attorneys in cases we're covering more regularly asked to get to people's personal phones, which used to be a complete no-fly zone. I think this is going to open some doors for that. Then you saw the fight over getting Proctor's personal phone. And now we have seen the culmination of that fight. And Proctor saying those texts are juvenile and regrettable. I don't know how MSP and Canton are going to address this in the days to come, but I'm sure there will be more to come. And if the history of Karen Reed's attorney is any precedent, this isn't everything, because they never tip their entire hand at the beginning. There's always more. I don't know where they go from here. We're going to keep following it and see. And I have empathy for the O'Keefes in their grief. John O'Keefe deserved a better investigation. He deserved a just, unbiased, and thorough investigation, no matter where it leads. Because in a lot of criminal cases, the answers that you find are not always the answers that you want. Families deserve answers and good and unbiased investigations. We haven't seen that with the death of John O'Keefe. And I don't know if we will. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.